think we have to draw a distinction between the service of process and the concept of state immunity. What actually happened here was that the claimants did not serve the process on the government of Malaysia as was required under Spanish law. And that is why the Spanish courts subsequently nullified the appointment of Gonzalo Stampa, right? But that per se is not an issue of state immunity. All that means is that that is the manner in which states have to be served. There is a process which is laid down under Spanish law, which was not complied with. And that is why the courts in Madrid actually nullified the appointment of Gonzalo Stampa as arbitrator and also nullified everything that he did. Now, in relation to your question on sovereign immunity, I think one must consider the fact that there are different views on sovereign immunity. Particularly, there are two approaches. One is considered as the absolute sovereign immunity approach. And that approach is adopted by certain countries like the People's Republic of China and Hong Kong, where what that means is that in the Chinese courts or the courts in Hong Kong, it is absolutely prohibited to sue other countries because countries enjoy absolute sovereign immunity. The second version of sovereign immunity, which is more generally practiced globally, is the notion of restrictive immunity. Now, I think the notion of restrictive immunity is best characterized by two English cases. Firstly, the case of Trentex against the government of Nigeria, and also the case of I Congreso Partido. In those cases, a distinction was drawn in relation to whether a state was being sued in respect of a commercial transaction or commercial activity. And in such cases, what the English courts held was that there is no immunity from suit. However, if a country is being sued for an act of state, and if you look at the Latin distinction, there is a distinction between iure imperii and iure gestionis. Iure imperii means an imperial act, an act of state, as opposed to a commercial transaction. And the courts in the Commonwealth generally, and I'm speaking about United Kingdom, Australia, and Singapore and Malaysia, will adopt a restricted immunity approach. That means that they will only allow suits against states where a state has engaged in a commercial activity, and such an activity cannot be characterized as an act of state. Now, coming back to the Sulu issue and how it relates to this issue of immunity, the claimants relied very much on the 1878 agreement between Baron Overbeck and Dent, and also the then Sultan of Sulu. Now, it's very important to make several observations here. First of all, the territorial area covered by that agreement is somewhat undefined, but it certainly does not cover what is the modern day Sabah. But it only dealt with a very small portion of land which, at that time, the Sultan of Sulu claimed sovereignty over, right? and even that claim is contested. Secondly, it must also be emphasized that there was no arbitration agreement clause or reference to arbitration as we would now know it in modern times. There was a reference in the agreement that disputes were to be referred to the Consul General in Brunei. Now, first of all, that position does not exist in the present time, and it's arguable that that is not tantamount to a reference to arbitration clause as we now know it. And thirdly, how Stampa came to the conclusion that because the Consul General of Brunei does not exist, and this is the appropriate forum for him to hold an arbitration, clearly is highly dubious. Additionally, one must also look at the subject matter of the agreement. It cannot be said that that agreement was in the form of a commercial transaction, but it was more in the form of a cession of territory. Now, a cession of territory would fall into the Iure Imperii category and therefore be the subject of absolute sovereign immunity. And in such circumstances, there would be no recourse to arbitration possible. And the arbitrator, Gonzalo Stampa, should have recognized that fact, that the subject matter was not arbitrable, because it was a matter which concerned the sovereignty of a country, because the subject matter was the cession of territory. Now, however, I must also at this point say that it is not something that should be automatically accepted, that Malaysia's current rights over Sabah are as a result of that treaty either, because one must look at what happened historically. Historically, the British Crown made Sabah a crown colony and exercised effective occupation and control over that territory. Now, under international law, as was stated in the Las Palmas case, where the arbitrator Max Huber laid down the principle that title to territory was acquired as a result of effective control and occupation, the British, therefore, acquired title to territory. And this title to territory was subsequently passed on to Malaysia in 1963 by the United Kingdom. So there are many issues that have to be considered in the context of sovereign immunity. First of all, very, very clearly, there was no arbitration agreement, and therefore it could not be said that there was a waiver of sovereign immunity by Malaysia. If, for example, Malaysia had entered into an arbitration agreement, then it could be argued that there was a waiver by it of its sovereign immunity over this subject matter. But in the present circumstances, no. Malaysia is not a party to the agreement between Dent, Overback, and the Sultan of Sulu. And it is arguable that Malaysia's rights over the territory of Sabah are rights which it acquired from the United Kingdom as a result of the Malaysia Agreement in 1963 and the act of giving Sabah and Sarawak and Singapore at that time independence and the formation of Malaysia. And subsequently, Malaysia's title to territory accrues by the fact that it exercises effective occupation and control. So all these matters taken together clearly point to the fact that it was a subject matter which was one, to be covered by complete sovereign immunity. It was not a commercial transaction. There was no waiver of sovereign immunity by Malaysia, and therefore it was perhaps wrong for the Spanish arbitrator, Dr. Gonzalo Stampa, to give the award as he did. Yeah. So those are my views in short on the issue of sovereign immunity on this point. I think the answer to that is quite very, very clear, because it has been a principle of international law, and it's also governed by the Vienna Convention on diplomatic privileges, that the diplomatic premises are inviolable, right? And therefore, I think it's very, very clear under Article 22 of the Vienna Convention on Diplomatic Relations, 1961, that it provides that the premises of a diplomatic mission shall be inviolable. The agents of the receiving state may not enter them except with the consent of the head of mission. And also France has a special duty to protect the premises against intrusion or damage under Article 22(2), which provides the receiving state is under a special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage, and to prevent any disturbance of the peace of the mission or impairment of its dignity. And then if we look at the nature of the immunities under Article 22(3), what it says is, the premises of the mission, their furnishings, and other property thereon, and the means of transport of the mission shall be immune from search, requisition, attachment, or execution. And I think, so those provisions are fairly clear. What I do also would like to add on is that under Article 30, it says, the private residence of a diplomatic agent shall enjoy the same inviolability and protection of the premises of the mission, right? So my understanding is that whilst an attempt was made to have the bailiffs survey the premises, once they were informed of the nature of the premises, they left. Yeah. So I think in this respect, the government of France is under an international obligation to observe the provisions of the Vienna Convention on diplomatic premises, and also on the premises of the private residences of diplomatic agents, as defined by the Vienna Convention. Basically, in relation to a matter such as territory, where the issues pertaining to the territory of a country are matters which are undeniably or indisputably matters pertaining to its sovereignty. Because, and the claim, the purported claim by the purported or alleged claimants relates to the claim that they allegedly make in respect of Sabah, right? Now, this will definitely impinge on the sovereignty of Malaysia. Therefore, the arbitrator in Spain should have held that this subject matter was not arbitrable, and he should have said that Malaysia's sovereign immunity means that the arbitration should not be allowed to proceed, right? But on the contrary, he proceeded with the arbitration, despite the fact that his appointment was in fact nullified by the Spanish courts. Now, all these matters are still before the French courts. So I think it would not be appropriate for me to comment in detail on ongoing legal proceedings. But as a matter of general principle, what I would say is that Malaysia's sovereignty was infringed by the arbitration because it dealt with an issue where Malaysia was entitled to claim absolute immunity on the basis that it was not a commercial activity, it related to the cession of territory, and therefore it was a matter wholly covered by sovereign immunity and non-arbitrable. Well, I think the issue of state immunity and sovereign immunity is one which is covered by customary international law anyway. So irrespective of whether you have introduced legislation, those rules of customary international law will nevertheless bind all states in the manner in which they function. However, I think it is a good idea for Malaysia to enact a State Immunity Act, because by doing so, all the ambiguities which may arise in terms of absolute immunity or restrictive immunity are taken away. But that will only be relevant insofar as what the practice is in Malaysia, right? When we are looking at these proceedings pertaining to the Sulu claim, as it were, we are looking at jurisdictional and enforcement issues which are happening outside Malaysia, right? So it may not have an immediate impact, it may not have an impact on what happens globally, but I think going forwards, it's a good thing. But one must also recognize the fact that the United Nations has also attempted to codify this issue of sovereign immunity. And there is at the moment, although it's not in force yet, a United Nations Convention on these matters, which is still awaiting sufficient ratification by contracting states in order for it to come into force, right? And the United Nations Convention is a good basis for Malaysia to look at in terms of having a very, very standard and unified global practice in relation to sovereign immunity. And, you know, which I think is something that it should look at very, very carefully when it is proposing to enact legislation on that point.